Hi, everyone. I think we'll just wait just another couple minutes and see if anybody else joins us. Okay, I think we'll get started. Hi, everyone. My name is Savannah Nelson, and I'm the Gunnison Basin Roundtable's Public Education, Participation, and Outreach Coordinator. Thanks for joining us today for this lunchtime webinar. Please make sure to keep your mic muted throughout the entire presentation and save any questions you have until the end. I'm going to turn it over to John McClow right away for his presentation on the history of the Black Canyon water right.
Can everyone hear me? I think so. Savannah, am I on? Yes, I see I am now the host. So, good afternoon, everyone. Um, the Black Canyon water right uh, history spans 37 years and engaged the Division IV Water Court, the Colorado Supreme Court, Federal District Court, and then back to the Colorado Water Court in the end. So to understand this water right, we have to start with the Federal Reserve water right. Now, I'm sure everyone knows basically what the geography is, but just for the point of illustration, we have here the Aspinall unit, which Blue Mesa Dam, Morro Point Dam, Crystal Dam. Here's the Gunnison Tunnel diversion. Then this green is the Black Canyon of the Gunnison National Park. So, Federal Reserve water right. Now,
John,
historically,
real
yes?
quick, I think you still need to share your screen. Just one second.
All right, I thought I had, but let's go back. You have to make me the host again, I guess. Okay, now can everyone see it? Okay, it says you can. So let's start again. Black Canyon water right spans 37 years. Engaged the Division IV Water Court, the Colorado Supreme Court, and the Federal District Court in Colorado. Then ultimately back to the uh, Colorado Water Court. I'm sure most of you know the geography, but here we have the Aspinall unit, Blue Mesa Dam, Morro Point Dam, Crystal Dam, the Gunnison Tunnel diversion, and then this green area is the Black Canyon of the Gunnison. So a water right at this location affects everything upstream of the Black Canyon. So we need to talk about what is a Federal Reserve water right, because that is important in understanding how significant the water right is to water users in the Upper Gunnison Basin. So historically, the federal government has left allocation of the use of water to the states, but there's a significant exception, and that's this Federal Reserve water right doctrine. It's a judicially created doctrine that was created and developed by the United States Supreme Court, and it provides that um, when the federal government withdraws land from the public domain for a particular purpose, it simultaneously acquires the right to sufficient water to effectuate those purposes. And the vested priority date of the water right is the date of reservation. Now, this doctrine goes back to a case in the Supreme Court in 1908 called Winters versus United States. It involved a dispute over the Milk River in Montana. The United States created the Fort Belknap Indian Reservation on May 1st, 1988. And then the Indian Service constructed a large diversion structure in the Milk River to let the tribes irrigate and farm the reservation lands. That structure was located downstream from diversions made by white settlers who had appropriated water after 1888 in accordance with Montana law. During the drought of 1904, the settlers diverted so much water that the reservation got none. So the United States took them to court and asked for an injunction saying that the Indian reservation water right was superior. And the Supreme Court said, yes, we have determined that the United States, when it withdraws land from the public domain, simultaneously acquires the right to sufficient water to effectuate its purposes. Now, for the years, it was just assumed that this reserved water right doctrine only applied to Indian reservations. However, in 1976, a rancher in Nevada was irrigating and competing with water with a federally protected fish called the Devil's Hole pupfish. Francis Capert was his name, and the case was Capert versus United States. And in that case, the court affirmed this Federal Reserve water right doctrine. It said it applies to any federal reservation. It does say that this implied reservation is limited only to the amount of water necessary to fulfill the purposes of the reservation and no more. Finally, then in 1978, in a case coming from New Mexico versus the United States, the Supreme Court once again affirmed that this Federal Reserve water right doctrine applies in any federal reservation. So the Black Canyon of the Gunnison, it was withdrawn from the public domain by proclamation of President Herbert Hoover on March 2nd, 1933. He made the reservation under the authority of the Antiquities Act of 1906, which provides that the president can withdraw lands from the public domain to protect historic landmarks, prehistoric structures, and objects of historic or scientific interest. President Hoover's proclamation declared that it appears that the public interest would be promoted by including the lands hereinafter described within a national monument for the preservation of the spectacular gorges and additional features of scientific, scenic, and educational interest. Black Canyon became a national park by act of Congress in 1999. So, history of the Black Canyon water right. Under the McCarran Amendment passed by Congress in 1952, the United States is required to adjudicate water rights in Colorado Water Court. So in 1971, the United States filed an application for confirmation of its water rights for the Black Canyon National Monument. Now, this application was filed as part of an adjudication of a large number of appropriative water rights together with Federal Reserve water rights for 7 national forests, 3 national monuments, a national park, approximately 1,500 public springs or water holes, and 2 mineral hot springs. The case was assigned to a master referee who conducted 19 evidentiary hearings participated in by 72 attorneys, resulted in 10,000 pages of transcript, and then he issued a 1,200-page master referee report. And then the referee's report was incorporated into a decree issued by the water court. With regard to the Black Canyon National Monument, it was a conditional water right with that priority date of March 2nd, 1933, but it wasn't quantified. Well, in 1982, Denver appealed that decision of the water court, claiming that um, there are no Federal Reserve water rights in Colorado. I mean, they argued that based on some federal statutes, such as the Desert Land Act of 1877, that was passed by Congress to encourage settlement in the West. Under those statutes, they were argued the United States had abandoned any interest in water in Colorado. They also claimed that under the equal footing doctrine, when Colorado was admitted to the United States, the federal government was divested of any interest in water in Colorado. They made a few other technical arguments, but the Colorado Supreme Court said, no, I'm sorry. Based on the Capert case and the New Mexico case, it's clear that the Federal Reserve water right doctrine applies in Colorado. And the unanimous opinion was written by Justice Erickson. And I quote, accordingly, we conclude that the United States possesses reserved rights for its federal reservations in Colorado in waters unappropriated upon the date of reservation of the federal lands from the public domain and in the amount necessary to achieve the primary purposes of the reservation, confirming what the United States Supreme Court had previously held. Here's a slight digression, and I'm doing this because it's important to the ultimate settlement we reached in the case. In the 1960s, when the Aspinall unit was being built, the irrigators in the upper Gunnison Basin were concerned that having this large reservoir complex downstream was going to hinder future development of water rights in the upper Gunnison Basin. So the Bureau of Reclamation said, well, don't worry, we'll subordinate the Aspinall water rights so it won't hinder your development upstream. And that was characterized in letters and memos and so on. But we finally formalized it in 2000 so that the Aspinall water rights are subordinated to 60,000 acre feet of annual diversions in the upper Gunnison Basin. Well, nothing happened for 19 years after the Supreme Court said that Federal Reserve water rights do exist in Colorado until 2001, when the United States filed an application to quantify that 1978 conditional water right. So the application said that the uses for which the application was being made was, quote, to ensure the continued nutrition, growth, conservation, and reproduction of those species of fish which inhabited such waters on the applicable reservation dates, or those species of fish which are thereinafter introduced, and to attain and preserve the recreational, scenic, and aesthetic conditions existing on the applicable reservation dates, or to preserve those conditions which are thereafter caused to exist. Now, that application set up a scenario where it wanted a year-round base flow between 300 and 3,350 cubic feet per second. Now, that was going to be determined every year by a formula based on inflows to the Aspinall unit. In addition, there was going to be a one-day peak flow determined annually by a similar formula, which in some years would have exceeded 14,000 CFS. And that created some serious concerns about flooding downstream, especially in Delta. Now, the ramping rates on that 14,000 CFS peak were also pretty significant, which caused some concerns about the variation of the flows in the canyon. Well, the water court granted 2 6-month stays of proceedings so that the U.S. could enter into settlement discussions with the concerned water users. And that did not succeed. The negotiations failed completely. So in the period during which statements of opposition were permitted, there were 386 statements of opposition filed, many of whom were individual water users in the Upper Gunnison Basin. The Upper Gunnison River Water Conservancy District agreed to represent all of the local water users in the water court. So why is this water right of such concern? in the upper basin. Well, this is an analysis done by our engineers for a dry year, which shows it most dramatically. And in that year, 1977, had the water right been exercised then, the the pink color, salmon color here is the demand of the Gunnison Tunnel, which is a very senior water right on the river. The blue line shows the natural inflows through the canyon, and the green shows the demand of the Black Canyon water right. Well, this water right, in a dry year, the inflows to the Aspinall unit were about 33% of average inflow. So this is a very dry year. This demand by the Black Canyon water right would have been short 218 days in 1977. So the river would be on a 1933 call for 218 days. Well, that's a particular problem in the Upper Gunnison Basin for irrigators because in the Upper Gunnison Basin, the original basin-wide adjudication was in 1906. But at that time, it was determined that the um, duty of water, that is the amount you could appropriate, was 1 cubic foot per second to irrigate 40 acres. And that worked out fine as long as there weren't too many competing water rights. But as there became more and more competition, it soon determined that there would need to be another adjudication because the ground in Gunnison consists mostly of gravel and it requires a lot more water. And the irrigators took that water in the beginning until there was too much competition to continue doing that. So in 1941, there was a subsequent adjudication in Division 59, in 1943 in Division 26, where they upgraded their diversions to 1 cubic foot to irrigate 10 acres. So basically, three-fourths of the irrigation rights in the Upper Gunnison Basin would have been junior to a 1933 Black Canyon water rights. So those three-fourths of the irrigators would have been called out by the Black Canyon in a dry year, and virtually every year, but it shows dramatically in dry years. It also would have called out storage in Taylor Park Reservoir, would have called out storage in the Aspinall unit, and the total shortage in 1977 would have been almost 120,000 acre feet. So it's a pretty dramatic issue as the application was filed. Carrying on. So beginning in November of 2002, we negotiated with the United States to provide that individual water users in the Upper Gunnison Basin would withdraw their statements of opposition, and in exchange, the United States would subordinate the Black Canyon water right to the individual's water rights, therefore taking off the risk of the call. By April of 2003, we had about 100 of those stipulations signed by the water users, and the United States, 50 of them had already been filed in the water court and approved. Well, the state of Colorado originally did not object to the stipulations, but suddenly they came back in 2007 and said, no, wait. This is a selective subordination. We refuse to allow you to utilize these stipulations. Well, as we continued to work on statements of opposition, Greg Walcher, who was the director of the Department of Natural Resources in Colorado, decided he could resolve this water right problem by going to Washington and negotiating a settlement with the Department of the Interior. So in April of 2003, Colorado and the United States announced that they had settled the case in a 1.5-page agreement. The United States gave up its reserved right to the peak and shoulder flows and a one-year year-round 300 CFS base flow. And it said that it would amend its application to just claim as a federal reserved water right 300 cubic feet per second base flow year-round. And then they came back in July of that year and entered a memorandum of agreement, I'm sorry, which conceded the federal water rights for the peak flow and said that the peak flows would be acquired by the Colorado Water Conservation Board as an in-stream flow with a priority date of 2002 or 2003, excuse me. Well, the environmental opposers did not care for this particular settlement because they didn't feel it was protecting the Black Canyon. So they filed a lawsuit in the federal court in Denver to set aside that agreement. So here's their argument. They say that this agreement failed to comply with the National Environmental Policy Act, that it was an illegal delegation of federal responsibilities, that it was an illegal disposition of federal property, and that it was an arbitrary and capricious action because it didn't adequately protect the park. Well, while that case was proceeding, the Water Court in Division 4 ordered a stay of proceedings in the water case, pending the outcome of the federal case. But some of the opposers in the water court wanted the water court to continue to adjudicate the water right in state court, regardless of the federal case. So they petitioned the Colorado Supreme Court to lift the stay, but the Colorado Supreme Court in 2004 said, no, we're discharging the rule to show cause, and the stay of proceedings will remain in place while the federal case proceeds. Well, the federal case went through motions and hearings. It was filed under the Administrative Procedures Act, so there was no trial. It was a question of examining the record that went into this decision to see if the record was adequate to support the agreement. So there were motions and briefs and a study of the record. But after 3 years in federal court, the judge set aside the agreement and he remanded the case to the National Park Service, which puzzled us all because we didn't understand what that meant. Ultimately, we decided that it was a remand to the state water court, and we went on. Now, here's what the federal judge said. The National Environmental Policy Act means that you have to make these decisions in public. It has to involve a public process, not behind closed doors in the Department of Interior in Washington. And delegating the peak and shoulder flows to the state of Colorado was not permissible. Said there's a consensus that the Black Canyon needs more than the 300 CFS base flow. So amending their application to seek a smaller amount than the need is a disposition of federal property, and only Congress and not an agency can dispose of federal property. And the most damning one was that the court found that this was an arbitrary and capricious action, and that it was the relinquishment of that full quantity of water right was nonsensical. So now we're back to the state water court, and the United States decided that the best approach was to involve settlement discussions rather than going to court again. So about 30 of the principal opposers got together and negotiated a mediation agreement and selected a mediator. And between September of 2007 and May of 2008, we conducted 12 mediation sessions. 10 of them were for a full day, 2 of them were for 2 full days. And the typical attendance at these meetings was about 50 people. So it was a very complex negotiation. And ultimately, we agreed to settle on a stipulated decree. And in the meantime, the stipulations for withdrawal that we had previously negotiated with the United States were revised and approved so that that subordination was agreed upon, and we developed some language in the stipulations that made the state comfortable that we were not, in fact, utilizing a selective subordination. these are the participants in that mediation. And if you take just a moment to look at the list, you can see that it's a very broad spectrum of water rights owners, users, and government entities. In dealing with the United States, it's important to understand that it wasn't a unitary body we were dealing with. There were five different federal agencies engaged in the mediation and the negotiations, and each one of them had a slightly different concern and a slightly different demand for the settlement of the water right. But we ultimately reached agreement with all these parties. Got a final decree January 8th, 2009, effective December 31, 2008. So what did we settle for? First of all, it's a year-round 300 CFS base flow, which is what the government originally applied for. And this graph shows how that base flow stabilized and maintained its constant flow with the natural inflows to the Black Canyon. The peak flow had a 24-hour duration determined annually by a formula based on the May 1 forecast of April through July inflow to Blue Mesa. Now, the difference is that between what the application asked for and what we ended up with is a formula that is based on the hydrology of that particular year. And we had six different categories of hydrology based going from very dry to wet. So using a dry year formula, we managed to maintain a reasonable peak flow that didn't have a dramatic effect on the river, either being, especially not being too high. So the way the decree defines the peak flow is illustrated in this graph, which is part of the decree. So on the bottom, you have the inflow to the Aspinall unit, the forecasted inflow. And on this axis, we have the volume of the peak flow in cubic feet per second. So in a dry year, number one category, if you have this inflow here, you just go up on the graph, and that point on the graph defines the peak flow. Likewise, in an average year, you start with this inflow and move to here, and that defines the amount of the peak flow. The maximum that it could be under this formula is about 10,000 CFS, which is significantly less than the 14,000 plus that the original application sought. And as you saw from the list, the folks in Delta participated actively in this mediations to make sure that their flooding concerns were responded to. Now, there are also shoulder flows during the period of May through July. If Blue Mesa inflow exceeds 561,000 acre feet, these are also determined by a formula, but there is a maximum of 1,000 CFS where the application would have permitted a maximum of 3,350 CFS. So it is what I would call a valuable, based on the Park Service and the other entities' decision, water right to protect the scenic and the natural wonders of the Black Canyon, but at the same time minimizes its impact on the other water users. So the decree can't be exercised to affect operations under the existing federal contracts. And that would be, for example, the Taylor Park Operations Storage and Exchange Agreement, Uncompahgre Valley Water Users project, the Uncompahgre Project's water stored in Blue Mesa, and the Dallas Creek Project, Ridgeway Reservoir Exchange, and other similar contracts. The Black Canyon water right and the decree is subordinated to Upper Gunnison Basin water rights. That is, for any water right where the individual water right holder did not obtain a stipulation for withdrawal, all water users in the Upper Gunnison Basin are protected by this subordination of the Black Canyon water right. In addition, the Black Canyon water right will honor that Aspinall subordination agreement. That is, all future water rights will also be subordinated to the Black Canyon water right, just as the Aspinall water rights are, up to 60,000 acre feet of annual consumptive use in any year. This is where we protect Delta. It can't be exercised to supersede the flood control operations in order to protect life and property downstream from the park. Under extreme drought conditions, we have provisions built in that will reduce the peak flow even below what's in that formula to allow the Aspinall unit to recover storage. Have to do it with due regard for the fishery in the Gunnison River. This was a significant point for the environmental interests and also for the Bureau of Land Management, which manages the Gunnison Gorge area just downstream from the Black Canyon. Also, it's also coordinated with releases under the Aspinall Unit Record of Decision to protect listed species and their habitat under the Endangered Species Act. And that's the summary of the history. So I'm open to questions if we can do that. I think, let's see. Savannah, can I unmute the participants so they, or can you?
Yes, we can do that now. Okay, does anyone have any questions for John?
I see Mr. Ken Span joined as a guest. He could have given his presentation as well as I could.
It was a long time ago, John.
I did have to check my notes, Ken. I did.
It was a long time ago, but the outcome was highly successful for everyone involved, I think, ultimately.
I do
It
too.
stabilized those issues.
John, could you maybe talk about how you personally were involved in the process?
Well, as I said earlier, the district agreed to represent all of the local water users. So I had about 300 clients uh, to make sure. I negotiated with the United States to get those stipulations for withdrawal. I was a principal author of the decree. The way we went about that in the mediation session is we basically put the draft language up on the screen and we rewrote it line by line with 50 people sitting in the room. Um, we would put together a draft agreed upon by the Justice Department for the United States and a couple of other lawyers and me, and we would throw it up on the screen and work through it. And I went back and renegotiated those stipulations for withdrawal for the Upper Gunnison water users. Everything you have seen is from my personal involvement and recollection, except the federal litigation. The district did not participate in the federal litigation.
Does anyone have any other questions for John? If not, I think we can wrap it up.
Hey, Savannah. I was going to ask John, what were the most difficult points of negotiation? Or which portions took you the longest? Which were the most contentious?
Well, the peak flow was the toughest one, I think, as part of the decree, because the original intent of the National Park Service was to duplicate the natural hydrograph that existed before the dams were built at the Aspinall unit. And as I think everyone knows, that was a highly variable hydrology. I mean, in some years it was very small, other years it was 15 or 16,000 CFS coming through in the spring. And so we were trying to provide that protection. I mean, we the opposers agreed that the canyon needed to have that protection based on its reservation, but we wanted to minimize the negative impacts on the other water users in the basin. And so the struggle was to find a peak flow that would satisfy the needs of the Park Service at the same time, not disrupt the whole water rights administration throughout the Upper Gunnison Basin. It took a lot of work to develop that formula that's on that graph. The formula itself is quite complicated, and that took several days of discussion and negotiation.
Thank you. Appreciate it.
Okay, I think we're through.
Awesome. Well, thank you so much, John.
I hope everyone was able to stay awake.
And thanks everyone for coming and listening. This will be recorded. Oh, Sonia has a question.
Nope, just clapping.
Awesome. Thank you. And this will be recorded and uploaded to the Roundtable website to refer back to. Awesome. Thanks, John.
You're welcome.